Hi Rhiannon, my name is Adil Rasool, and I will be advising you on the situation you find yourself in with your employers, Create Limited. Unfortunately, I hear that they believe you are self-employed, which is the primary reason for withholding the 1,000 bonus that you believe you're entitled to. In order for you to receive such a bonus, we need to first ascertain whether you are an employee or whether you are actually self-employed. The way in which we do this is basically we firstly have to define what is actually an employee. This comes under the statute of Section 230 of the ERA 1996, subsection 1, where it clearly states that this defines someone who is working under a contract of employment. Under subsection 2, it states that the contract of employment is a contract of services. We must now look at the tests which involve to see whether you are actually an employee or self-employed. The prior tests used to be something called the integration test. This test states that one has to be integrated into a company in order to be an employee. However, under the case of Stevenson, this didn't really survive, as anyone could be said to be integrated into a company even though they were not employees, i.e. independent subcontractors, etc. The second prior test, which is now modified into the main test, which I will be talking about in a couple of seconds, is the control test. This is where a person has to provide his own personal services, no unlimited right to substitute, subject to the control of another to a sufficient degree. And finally, the provisions of the contract must be consistent with a contract of service. This case survived into the modern basic requirements, of which is now the irreducible minimum. Although it would be argued that is one really under sufficient control if he is an airline pilot or other highly skilled worker. The main case now we have to look at in being able to see whether you are self-employed or an employee is, under the common law, the irreducible minimum. The leading case for this is the RMC. This will clearly try and help us outline whether you are an employee or not. The three tests have to be complied with to ensure that the status of employee. The three tests consist of a personal service, the control test which I spoke to you about previously, but they have adapted it and made it a bit more sufficient in trying to make a self-employed person or an employed person more clear. And finally, mutuality of obligation, which I'll be expressing about. In relation to you, we need to look at things, start off with the personal service. I believe you have a certain amount of personal service in Craig Limited, as you have a highly skilled aspect of work, which is to design computer software for the Craig Limited. Personal service means that you have to carry out your own work, using your own skill in return for wages or other remuneration. Seeing as you do not delegate the work to anyone else, nor do you have an unlimited right to substitution, which is carried out in the Canton case, by the way, we can say that you have successfully completed this obligation of the irreducible minimum. We can also see that you have a fair degree of control in the workplace. This is backed up for you in the case of Younes v Nooks, where Branwell stated here that a servant is a person who is subject to the command of his master as to the manner of which he should do his work, meaning you are required to do the work the employer set out for you. Relating to your situation, we know that when there is emergency in the workplace, you are called upon, which shows to me that Craig Limited does have a sufficient control over you. Also stating that you are obliged to fulfill 20 hours of work of service. In order to help with your battle, I'm also told that you are provided with a laptop and a desk is provided for you, showing us that there is control over you, and this is also looked up in the case of Airfix Footwear v Cape. Another point which can help you is mutuality of obligation is determine whether a contract, in your case, there is no written evidence to show that there is no contract. However, because of the amount of years you have been working for the company, it may mean that you have a contract, assuming that you have one, because there's no further information I've received on whether there is a written contract out for you. The second concept may also be satisfied, as you have been given work in which you conduct and in return is provided financial benefit. Things which may work against you, I'm afraid. The courts could say that well, for what I'm told, I can clearly see that you pay your own NI and tax. This is a tip for the balance of favouring the self-employed status. employees are supposed to deduct these contributions under the pay regulations, and I can see that they are not doing that, and you are enforcing this yourself. When looking at the accordance of element of substitution, I can see that you are only able to, well, sorry, your contract consists of you working 20 hours a week, and in these 20 hours a week you can come and go as you please. I mean, this shows that you can easily be replaced by another person if you're only working, well, minimum hours a week. This is also backed up in McFarlane v Glasgow City Council case. The courts will also look at another side of mutual obligation, which is to show the future lack of mutual obligation, where the courts may rule against you and say that you're unable to foresee a contract. This will show the court that a future mutual obligation is hard to see, as you are shown to also undertake work for other independent contractors, which you have stated, which could lead the balance on to saying that the judge could overrule it and say that you could be self-employed because you're doing work for other independent contractors, which showed in the case of Kelly of Trust House. Courts, however, will look at the contract, not really unless companies. Courts will always look at the contract, not reality, unless companies are using a sham, so don't have to recover liability. Overall, I see that in order for us to comply with all these tests, we need to make sure that the factual matrix is in place. These are basically all the tests I've just said above. What we need to realise is that as the mutuality tests have been applied, it still does not establish whether you are actually an employee or not, because we have to look at something called a factual matrix, which I just said. Therefore, status is a question of fact, not law. To summarise, a guy quoted called Nolan J states that in a case of Hall v Lorimer, that the objective of the exercise is to paint a picture from the accumulation of detail. This simply means that the courts will look at the whole picture and there will be no conclusive picture to what the outcome may be. In my personal opinion, I think your case could go either way on the day. What I mean by that is that I believe that the case is quite strongly typically balanced over to the side of you being self-employed, clearly to the fact that you pay your own NI and tax, you're only working 20 hours a week, shows that you can be replaced, and the main point is that there's no foreseeable of mutual obligation in the future, showing that whether your status there is permanent or not, whether you can carry on fulfilling your work throughout a long period of years. Thank you very much. Take care. Thanks.